Thanks, Madam Chair. Mr. Cole, in your opinion, is NSA's Section 215 bulk telephony metadata collection program conducted in accordance with our Constitution and the laws of the United States?
Yes, Mr. Vice Chairman, it is.
Ms. O'Sullivan, could I please get your answer to the same question?
Yes, it is.
Mr. Leggett, do you agree with me that NSA's bulk telephony metadata collection system has been one of the most heavily overseen programs in the intelligence community?
Yes, Mr. Vice Chairman, I do.
Mr. Giuliano, this bill would extend the sunsets for both lone wolf and roving out to December 31, 2017. Seems to me that these two provisions are pretty non-controversial at this point. The only reason we kept extending these sunsets was because of the concerns about the 215 bulk data collection program, which this bill is going to eliminate. Have there been any abuses of the roving or lone wolf provisions to your knowledge?
No, sir, there hasn't.
Would you be in favor of making the lone wolf and roving provisions permanent?
Yes, sir.
Mr. Cole, do you agree with that?
I think that would be appropriate, Senator,
Okay.
yes.
Mr. Leggett?
Yes, sir.
Ms. O'Sullivan?
Yes, sir.
Mr. Leggett, the NSA has been subjected to a lot of unwarranted abuse since Snowden's treasonous disclosures. I want to publicly thank you and all the patriotic Americans who serve our nation by quietly performing NSA's vital mission. In your opinion, is this country safer or less safe after those damaging disclosures?
Mr. Vice Chairman, first, thank you for the words of support to the NSA workforce. We appreciate that. In my opinion, the country is less safe because of the disclosure of the methods that we use to conduct our authorized foreign intelligence mission.
It doesn't appear to be, there doesn't appear to be any requirements in the bill for the service providers to retain call detail records for any set period of time, as you just discussed with the chairman. Mr. Leggett, if service providers decide to scale back their data retention period, how would that impact NSA's mission?
Mr. Vice Chairman, that would make it make the information less useful for providing intelligence on the external threat with a U.S. nexus, and so we would come back and inform the committee if that became the case.
Mr. Giuliano, how would the FBI be affected if the service providers unilaterally decide to cut back their retention periods?
So I think it would affect both the richness of the data and the usefulness of the data, sir.
Would it make other investigative techniques like grand jury subpoenas and national security letters less effective?
I'm not sure it would make them less effective, sir, but if the data is less rich and there's less data to use, it would impact the value of the data.
Okay. Now, I'm in favor of providing a statutory basis for the FISA court to use their inherent judicial authority to appoint amicus curiae when the courts determine that it would be appropriate. And in our bill, we made a provision for that. Section 401 requires the court to appoint an amicus to assist the court in situations involving, and I quote, novel or significant interpretations of the law, unless the court issues a written finding that such appointment is not appropriate. Now, this seems like an unconstitutional infringement upon the judicial branch's power to interpret the laws of the United States. We routinely trust our courts and judges to make these sorts of interpretations in ex parte situations in the criminal context. Now, Mr. Cole, do you think it's a good idea to try to impose this requirement on FISA courts?
Well, Mr. Vice Chairman, I think as a practical matter, the courts will be appointing amicus when there is a significant and a novel issue that comes before them, and I think that that will happen in the due course. This doesn't require them in all instances to. It just says if for some reason they decide that they don't want one, they just have to put their reasons in writing. But my expectation is that when it is significant and novel, the courts generally will want to have another point of view and have an amicus come in. So I think the operation of it will be virtually the same as if it was just the inherent power.
So what if you run into a judge who just in every case decides that they're going to make a determination that we don't need an amicus brief. Do you think it's going to be incumbent upon the DOJ to review those decisions that judge makes?
No, I don't think there's a mechanism that requires the Justice Department to oversee how the court is employing this. This is still within the sound discretion of the court to appoint an amicus in the significant or novel cases. It's just that when you have one that is significant or novel and they don't, they need to merely state their reasons if they don't appoint one, why.
Thanks, Madam Chair.